Officer in charge can always argue a matter, but your counsel should be properly briefed. यहाँ ऐसा नहीं है कि उठ के आए और फाइल यहीं खोली और यहीं शुरू हो गए. तो आप ब्रीफ करिए, आप पीछे से खड़े होकर मत बताइए. Your counsel should be properly briefed. If your counsel is not properly briefed, आपको दे रहे हैं, मौका देंगे आपको. कोई अभी कंक्लूड थोड़ा ना करना. This is their contention.
Yes, sir.
इस कोर्ट में तो आपका कोर्ट मार्शल चलेगा नहीं.
Yes, sir.
उनको भी कहने का मौका देंगे हम, और जो कहेंगे उसको आप रिबट करिएगा. कहाँ अटैचमेंट हुआ है इनका?
In Jabal.
आपसे नहीं पूछ रहे मैडम, वकील साहब को बताइए. नहीं तो यू रिमूव हिम, यू आर्ग्यू, आई विल परमिट यू टू आर्ग्यू. एंड इसके लिए भी आर्मी लगेगी क्या? टेक्नोलॉजी सिखाने के लिए
जरूरत नहीं है. आर्मी की जरूरत नहीं पड़ेगी सर.
विक्रम जी, आपकी तैयारी आजकल क्या, पढ़ नहीं पाते क्या? ज्यादा केस हो गए हैं.
नहीं, it's not that.
तो पढ़ते क्यों नहीं है आप?
It's not that.
योर लॉयर इज नॉट प्रिपेयर्ड, यू आंसर इट. आप लोगों के बारे में नाम आ गए थे ना कि किस किसने गलती की है. तो आप ब्रीफ करिए, आप पीछे से खड़े होकर मत बताइए. योर काउंसिल शुड बी प्रॉपर्ली ब्रीफ्ड. इफ योर काउंसिल इज नॉट प्रॉपर्ली ब्रीफ्ड, देन आई विल नॉट हियर यू.
आरटीओ लॉ सेक्रेटरी
काउंसिल को पहले ब्रीफ करते नहीं करते हैं. कहाँ अटैचमेंट हुआ है इनका?
In Jabal.
आपसे नहीं पूछ रहे मैडम, वकील साहब को बताइए. नहीं तो यू रिमूव हिम, यू आर्ग्यू, आई विल परमिट यू टू आर्ग्यू. एंड आई विल से दैट आपका शुभ नाम लिख के दैट यू हैव डिस्चार्ज योर काउंसिल, यू विल आर्ग्यू द मैटर. आई विल परमिट यू टू आर्ग्यू दिस मैटर. देयर इज नो प्रॉब्लम. ऑफिसर इन चार्ज कैन ऑलवेज आर्ग्यू अ मैटर, बट योर काउंसिल शुड बी प्रॉपर्ली ब्रीफ्ड. यहाँ ऐसा नहीं है कि उठ के आए और फाइल यहीं खोली और यहीं शुरू हो गए. Then I'll have to observe certain things about the conduct, because that amounts to wastage of the court's time. Where is that order?
attachment order also.
I don't know. You're
Yes.
referring to clause A of the relief sought.
It is there at page 15 in the original writ petition also.
Annexure
P1,
P1.
page 15.
You are Mr. Mukesh Srivastava.
Yes, Lord.
Huh.
The forwarding officer are hereby attached to the units mentioned against each for further disciplinary proceedings under the provision of Army Instructions 30/86 with immediate effect till finalization of the discharge case, disciplinary case pending against them.
Ji. 107 GL Sector Type B, 12 Corps Southern Command to GRC Headquarters Madhya Bharat area. Ji.
So he has been attached at Jabalpur itself in MB area GRC also.
P1.
Now what is my respective submission?
Just a minute.
Yes.
Annexure P1 dated 6th April 2023. Petitioner attached to GRC/HQ Madhya Bharat area. Ji. Then now come to your this thing.
Now I also mechanically appreciate the relief which has been sought before the tribunal.
Yes.
What he has been seeking in clause 8 relief to direct the respondent number 4 to 5 to issue movement order to the applicant to report to his unit in the interest of justice. So what he has been seeking that he should send back to the unit where from he has been attached to at Jabalpur itself.
This petition was filed on which date?
Is in OA lordship. Original application which has been filed before the AFD.
This is dated 9/9/23.
Yes, lordship. 9/9.
OA is 9/9/23.
So yes.
Now
I also kindly appreciate.
Just a minute. Where is the reference to the order dated this 6th April 23? When did he join in pursuance to the order dated 6th April 23? That is annexure P1.
Lordship, he joined.
विक्रम जी, आपकी तैयारी आजकल क्या है? पढ़ नहीं पाते क्या?
It's not that.
ज्यादा केस हो गए हैं.
Like it's not that.
तो पढ़ते क्यों नहीं है आप?
It's not that lawsuit because that date of joining is not there because it has not been the issue.
You should have been prepared. आपकी मैडम ने 2 बार टाइम लिया सिनॉप्सिस बनाने के लिए.
Joining का period. 6/4/2023 lords.
6/4 को तो he was directed to be attached.
Yes.
Then he joined on the same date.
Within a week's time, he moved.
When did he moved? I'm asking you the date when he moved.
Lordship, according to the rules, the moment we get a movement order, we have certain days to join from the said location, get the...
He joined, he obeyed this order.
He came here, yes.
Now you reply my queries. Your lawyer is not prepared, you answer it. Then this attachment annexure P1 was for a particular purpose. Attached to units mentioned against each for further disciplinary proceedings under the provisions of Army Instructions 30/1986 with immediate effect till finalization of disciplinary case. When was the disciplinary case finalized?
Your Lordship, if I may submit a few things before you to appreciate the sequence of events.
जी बताइए.
Your
आप
Lordship,
बैठिए, विक्रम साहब आप बैठिए.
Yes, yes.
जी बैठ जाइए.
Your Lordship, in Army, when some disciplinary proceedings are ordered, that is done after a fact-finding investigation into the subject.
Right.
So whenever we get the knowledge that something has happened which may amount to an offense, we ordered something called a court of inquiry, which is akin to a police investigation, roughly, and it is a fact-finding body. After that investigation completes, that goes to the convening authority who gives a direction on after examining whether prima facie something has emerged during that investigation. So in this particular case, I mean, I'll get to the particular case later. I'll just explain the sequence of event. So once that direction comes, it will say that so-and-so has been found blameworthy for this prima facie, and accordingly you disciplinary proceeding be initiated against him.
Right.
Now, once that happens, that disciplinary proceeding comes in various stages, Your Lordship.
Right.
So it starts with something called a hearing of charge, which is Army Rule 22, Your Lordship.
Army Rule 22.
Yes, Your Lordship.
Just a minute.
So, Your Lordship, Army Rule 22, it is at this stage, we have taken note of the court of inquiry, and we've given them certain preliminary, this is a pre-trial stage basically. So the commanding officer sees whatever prima facie evidence has come in the court of inquiry, and then if it is a case worthy of being tried by court martial at a later stage, then it is mandatory for the commanding officer to order reduction of the summary of evidence, which is the following rule, Your Lordship, Army Rule 23. Now, Army Rule 23, when the summary of evidence is recorded in writing, then that summary of evidence is processed to the convening authority, who will examine that evidence and then come to the conclusion whether or not a case has to be tried by a court martial or not.
Right.
So I'll just read out, Your Lordship, Army Rule 23, if you may please see. Your Lordship, it says procedure for taking down summary of evidence, that where the case is adjourned for the purpose of having the evidence reduced to writing.
Writing लिखा हुआ है.
Sir, वो typographical error
पर
probably.
भी कोर्ट मार्शल चलता है क्या? चलिए.
In writing, the adjourned hearing of evidence of the witness who were present and gave evidence before the commanding officer, whether against or for the accused or any other persons whose evidence appears to be relevant, will be taken down in writing. Then, Your Lordship, if you could just come to, so it just lays down the procedure that we'll give a caution to the accused and so on and so forth. When this summary of evidence completes, then the following rules talks about remand of the accused for trial.
जी.
So what I'm trying to apprise to the court here today is that this stage has not even been reached. The particular petitioner
is there any time limit to?
Yes, Your Lordship. That is what, sir, Your Lordship, if I can walk you to Army Act Section 122.
Yes.
122 Army Act, that's on page 33 of the Bar Act. It says that except as provided by subsection 2, No trial by court-martial of any person subject to this act for any offence shall be commenced after an expiration of period of 3 years. So what I'm trying to explain here is that from the starting date, that is once the direction of the convening authority has...
No,
Yes.
sorry. 122 says that the day on which an act of delinquency was committed, then the limitation will start from that date of commission of the delinquency, and then there are certain circumstances given, that is A, on the date of the offence,
Yes,
or
Your Lordship.
where the commission of the offence was brought to the knowledge of the authority on a particular date, then that will be the starting date.
Yes, Your Lordship.
Now you are required to point out
Yes, Your
as to
Lordship.
on which date his act of delinquency was brought to your notice.
Yes, Your Lordship. That's what I'm trying to explain, Your Lordship. In Army Rule 120, Army Act 122, in provision 1B, it talks about two situations. The first part of it is, my argument is that we are not affected by the first part of the clause B, which basically says where the commission of the offence was not known to the person aggrieved by the offence. What we are saying is that when... See, I have quoted one Supreme Court judgment, Your Lordship, in the synopsis.
Later on.
Yes.
Judgment
So-
comes later on.
Of
First
course.
facts.
Okay, I will explain, sir.
Don't try to behave like a lawyer.
No, sir.
Judgment bombard कर दिया, facts का कोई पता ही नहीं है.
No, sir. I'll tell you the facts, sir.
जी.
So, when the surprise check was done, then we did a
When
court
was
of...
it done? When was it done?
Your Lordship, in the synopsis, if you may please see.
Where is the synopsis?
Your Lordship, I've filed a synopsis further to the directions of the court.
जी.
Your Lordship, the surprise check was done.
Synopsis निकाल के दीजिएगा इसमें से, फाइल में से. Synopsis निकाल के दीजिए. फाइल किया है और देख लीजिए आराम से. यही है सिनॉप्सिस. इसको खोल लीजिए, फाइल खोलिए, उसको कैट से निकालिए, दीजिए इसको. इससे निकाल लीजिए ना. Yes.
Your Lordship, the surprise check was done on 29/01/2020.
29/1.
01/2020.
Surprise check.
Yes, where we found that there was something amiss, based on which...
एक second.
Yes.
Check was made. So that is the date of knowledge as per...
No, Your Lordship. No, I'll explain that, Your Lordship. I'll explain that, Your Lordship. So we figured that something is amiss. However, we neither know who all, if how many people will be involved in that. Accordingly, Your Lordship, we started the investigation on 21/08/2020.
When did you start the investigation?
The court of inquiry commenced on 21/08, serial number 4 of the synopsis, Your Lordship.
2020.
2020.
Court of inquiry initiated.
Yes, Your Lordship. That investigation got completed.
जी.
That got completed, Your Lordship, on 8/2/2023. Whereby, this is a serial number 5 of the synopsis, Your Lordship.
जी.
Whereby the whole of court of inquiry proceedings were examined, and the GOC, who Madhya Bharat area, he gave his direction against a total of 9 individuals. That various different lapses have emerged against total 9 individuals. So, Your Lordship, what I am trying to get at is that after this court of inquiry happens, now in reference to all these 9 people, separate proceedings will be initiated. And that is why summary of evidence was ordered. First the judicial...
Just a minute, wait for a minute.
Your Lordship.
Yes.
So, Your Lordship, once the directions come of the GOC, that is 8 February 2023, That
The limitation will start from that.
Yes, Your Lordship. That is what I'm trying to explain on 122(1)(b). That is when the authority competent to initiate action came to the knowledge of the offence.
Right.
So, Your Lordship.
Where are the proceedings of the court of inquiry which were initiated on 21/8/2020?
Your Lordship, whereas Your Lordship, they have been examined in the.
You say that court of inquiry, this surprise check was made on 29/1/2020.
Yes.
Court of inquiry was started on 21/8/2020.
Yes, Your Lordship.
There is lapse of about 7 months' time.
Your Lordship.
Just a minute,
Yes.
please. Then you say that for the first time on 8/2/23, Court of Investigation on completion came to know that who are the delinquent persons. Right?
Yes, Your Lordship.
Now, what is the documentary evidence in support of this, that the date of discovery of the delinquent officer is